this case might look like a routine eviction hearing, but within minutes, it turns into a masterclass on how small lease clauses, missing witnesses, and confusing paperwork can completely flip the outcome of a courtroom battle. On one side, you have a property management company armed with exhibits, screenshots, and videos. On the other, a tenant representing herself, nervous, emotional, but determined to defend her home. What starts as just a lease violation quickly spirals into debates over smoking policies, redacted evidence, alleged threats, and even accusations of forged signatures. And here's the twist. This isn't about unpaid rent. This is about behavior, interpretation of contract language, and whether the landlord can actually prove what they're claiming. As this hearing unfolds, watch closely. Who actually has proof? What counts as real evidence versus assumption? And how much weight does a judge give to screenshots and emails without live witnesses? Because by the end of this session, we're going to see something that surprises a lot of viewers. A landlord who came in confident, slowly losing ground, piece by piece, simply because the legal standard of proof wasn't met. Stay with this one. The smallest line in a lease might end up deciding everything.
The Med-V Group doing business as the Arts of South Austin versus Leah Couch. On behalf of the Arts.
Good morning, Your Honor. Gabrielle Smith and Nathan Marroquin.
Good morning, Ms. Smith.
Morning.
Do I have someone here on behalf of Leah Couch? Ms. Couch, I can see
I'm representing myself, Your Honor.
Good morning. Thank you for being with us. All right, Ms. Smith, why is this eviction sought?
Yes, Your Honor, this is not a non-payment case, so I get to be a little unique in that. Today, this is a matter of various lease violations. The lease was attached to our petition. I've also provided a copy to the court last week as well. And the notice to vacate was issued on October 16th, and this petition was filed October 21st. Under the lease provisions, the apartments are supposed to give at least 24 hours notice. They did give at least 3 days notice. And there are various lease violations, but and most importantly, the reason why there was a three-day notice to vacate period is the provision regarding threatening, aggressive, or intimidating behavior towards other residents and staff. And you'll see attached to the exhibits that were provided to the court. In Exhibit A5, there are various complaints from tenants in the community who submitted these to the leasing office concerning lease violations regarding smoking marijuana, but also concerns about their safety and safety of themselves and for others in the community.
Right away, notice how the landlord's attorney is building a volume strategy. Multiple complaints, multiple exhibits, multiple alleged violations. This is a common courtroom tactic. When you don't have one devastating piece of evidence, you present many smaller ones to create the impression of a pattern. Marijuana odor complaints, aggressive dog behavior, loud music. It's less about one rule being broken and more about portraying the tenant as a recurring problem. But here's the legal nuance. Quantity does not automatically equal quality. Each allegation still needs to stand on its own with identifiable proof. Anonymous emails and generalized complaints often weaken a case if they can't directly tie behavior to a specific individual. So the real question becomes, are these violations provable, or are they just community frustration turned into paperwork? If you were the judge here, would repeated complaints alone be enough, or would you demand direct, undeniable evidence?
And I also provided, Your Honor, 3 different videos, and those videos relate to showing violation of the pet policy with her dog being off leash. Again, loud and aggressive behavior, as well as smoking next to the building after being told not to. And finally, violation of quiet hours and playing loud music after hours, in violation of the community rules. Community rules were provided as Exhibit A2 in the exhibits that were provided to the court last week. And for these reasons, we would ask the court for immediate possession of the property.
Right. Ms. Smith, always just a question because it goes into the bonding situation. What is the monthly rent?
The monthly rent, Your Honor, is, and my apologies, I had it up here. The monthly base rent is $1,283.
And is the defendant responsible for the entire portion?
Yes, she is. I know she does have a guarantor, but yes, she is responsible.
Okay, all right. Let's just take a look. Ms. Smith, let me take a look at what you said here. So you said that there were some redacted corrections. Ms. Couch, I'm absolutely going to give you a chance to speak. First, we have to let the
Thank you
plaintiff give me
so
their
much.
stuff, and then you get a chance to respond. Absolutely, okay?
And Your Honor, I did provide redacted copies in case they were going to be shown publicly.
I'm
But if the
double
court would
checking that.
like,
I see the redactions. I always take a look at it before I throw it out there.
yeah,
So I
yeah.
really appreciate this. All right.
Thank you.
All right, I'm going to share my screen. Ms. Smith, this is what you've pre-marked as 22 pages as Exhibit A5.
This moment is
So-
critical. The judge is now scrutinizing the redacted emails, and redactions in court are a double-edged sword. They protect privacy, yes, but they can also strip evidence of its identifying power. If the judge can't clearly see who wrote the complaint or who it's about, the document starts to look less like proof and more like hearsay. And look at the tenant's reaction. I've never seen these before. That introduces another legal concern, fair notice. If one party hasn't had proper access to the evidence, it can affect credibility and even admissibility. In eviction cases especially, clarity matters. Courts aren't just asking, did something happen? They're asking, can you prove it happened to this person beyond reasonable doubt for a civil standard? When identification gets blurry, the entire argument starts wobbling.
So I'm going to zoom out. You can see it's 22 pages, lots of things. Okay, Exhibit A5. This looks to be an email address. You've redacted who it's from, but it's to an Arts at South Austin.
Yes, Your Honor.
Do any of these directly identify Ms. Couch?
Yes, some do. And then if you look at, for example, this one that you have on the screen right there, it refers to the resident in 2011. If you look about the middle of the screen, and that is Ms. Couch's unit.
I've never seen these before, Your Honor, and they're not in my copy of the paperwork.
Okay, Ms. Couch. And Ms. Smith, what unit? You said Ms. Couch resides in unit 2011?
Yes, Your Honor.
All right. Is there a policy or a rule that says you cannot smoke on site?
So there is a no smoking addendum, and then further in Exhibit A6 that was provided to the court, there is dialogue between Ms. Couch and property management after reports of kind of smoking violations and kind of pervasive odor of smoke in the community, and further instruction about how to abide by the smoking policy, and that's in Exhibit A6, but the non-smoking addendum is Exhibit A3.
All right.
And yes, ma'am, that is me, but I also have a medical marijuana license, which was turned in before I moved into the home.
Ms. Couch, you're fine. Governor Abbott has made a giant approval of some of this stuff. My question is not whether you're smoking illegally, it's whether the lease allows smoking at all, right? I'm going to get to that. Ms. Smith says it's an addendum. We're going to see it. So thank you for identifying yourself in the photos. Cool. People sitting outside and smoking. All right. None of these directly call Ms. Couch out.
And while some of these, I know there is follow-up with the management office confirming that these were regarding Ms. Couch, like I said, some of them do refer to her by name, some refer to her by unit number. But I did verify with the leasing office that these were in connection with this tenant and this unit.
Also, I want to add that Emily Hernandez, the property manager, was discharged from Minerva Group the day that the threats and the allegations were made.
Who's talking?
It's me, Your Honor.
That was Ms. Couch.
Okay, give me a minute, right? So far. Ms. Smith, do you have any witnesses other than these affidavits?
Your Honor, I actually did have witnesses who were planning to testify over the weekend. They advised me that they did not feel safe testifying. I'm happy to provide you those emails where they
Well-
withdrew from testifying, but
I don't
Your
doubt
Honor.
that's true. The problem is that none of their emails identify her as other than like they just say it's a woman by the office, which
and Your Honor, let me,
let's take a look at the videos, right? More importantly, Miss Couch said she was smoking, and I saw the picture of her smoking. Is the addendum about smoking included?
it is included at A3.
Okay, let's take a look at that.
And then there's also a video of smoking as well.
All right. So this is what's
They-
titled as A3. It says it's a lease addendum regarding smoking to the arts apartments. Now I see that there's an electronic signature at the bottom here. And so I see an Emily Hernandez signed 7/14/2025, and then a Leah Couch signed July 11th, 2025. And Ms. Smith, is July 11th when this lease was created by the parties?
I believe it's
Yes,
July
ma'am.
11th or 12th, Your Honor. Yes.
Now we
All
hit
right,
the
Ms.
heart of the
Couch,
case, the smoking addendum. This is where contracts become battlegrounds of interpretation. The tenant claims forgery and confusion. The landlord relies on electronic signatures and timestamps. In modern leasing, e-signatures carry serious legal weight, often equivalent to handwritten ones. But here's the twist. Even when a signature is valid, what the clause actually says is just as important as whether it was signed. A signed contract with ambiguous wording can still fall apart under judicial scrutiny. Judges don't just look at "did you sign?" They also look at "was this clear? Would a reasonable person understand it?" So now we're watching two parallel arguments unfold: authenticity versus interpretation. And in eviction law, interpretation often ends up being the
11th
deciding
or 12th,
factor.
Your Honor. Yes.
All right, Ms. Couch, you recognize your signature at the bottom?
I do not. There has been a couple of documents that have been forgified by Emily Hernandez,
Ms. Couch,
including
Ms.
the.
Couch, just say yes or no.
Yes.
You said no, you
Oh,
don't
no,
recognize
ma'am,
it.
I do
That's
not.
fine. Let me take a look at it. All right, here's what says the lease addendum regarding the apartments. Smoking in any form anywhere inside or inside the buildings is strictly prohibited. This extends to residents, occupants, guests who are present in any portion of the community. It extends and is not limited to the leasing offices, the building interiors, the hallways, the common areas, the dwelling units, the clubhouse, the exercise, the tennis courts, interior areas, all the interior areas. Smoking is permitted only in designated areas. The permissible smoking areas are marked by signs. Smoking on balconies, patios, and limited common areas is permitted. Only the following outside areas may be used. And then there's absolutely nothing indicated. So there's
Yes,
nothing
Your Honor.
about feetage. It's empty as to feet. So what I got is a photo of her smoking by a fence. How is that a violation of this?
Yes, Your Honor. That was included because it was attached to the email. There's also a video, and it is at exhibit. Sorry, I thought
It's
I
still
had
not a
it.
violation.
Well, and I'll get to that, Your Honor. It is exhibit. I believe it's exhibit E, the video recording, and the non-smoking addendum also says that if there are, looking at page, looking at section 3, it says, even though smoking may be permitted in certain limited outside areas, we reserve the right to direct that you and your occupants, family guests, and invitees immediately cease smoking in those areas if smoke is entering a dwelling or building, or if it is interfering with the rights, comfort, health, safety, or convenience of others in or near the apartment community or rental premises.
But it's impeding on my health.
And so and looking at exhibit A6, there's communication between Ms. Couch and Ms. Hernandez regarding where she can smoke, and kind of referring her to further away from the dwellings. But looking at exhibit E, she is smoking kind of in those same common areas near the building.
Let's just real quick. Ms. Couch, I'm taking a look at the lease. You recognize this lease, Ms. Couch? Ms. Couch, do you recognize your lease? Ms. Couch, I'm not able to hear
Yes,
you.
ma'am. Can you hear
Okay.
me?
Yes, I can. I can hear you now. Is this a copy of the lease you signed?
Yes, it is.
All right. You see that it was electronically done July 11th at 12:59, which provides me with reference that this addendum lease that has the same signature and date time was a part of that lease. Okay, so there's a no smoking addendum for inside the building unless it's with all these special restrictions, and then you gotta be, or again, it's kind of, don't do it inside. All right. Now, Ms.
Yeah,
Smith,
and
you
I have
said
not.
Ms. Smith, you said there's a
Oh.
video. Which video would you
I
like?
believe it's Exhibit E.
Okay, let's take a look. Windows Media Player, I guess I'll use that. Yeah. All right, I'm gonna stop it. I'm gonna share my screen. And then Ms. Smith, if you can identify this for me.
Yes,
I'm gonna include share sound. All right, Ms. Smith, Ms. Couch, are you able to see this video? The square, it starts at the top, it says ring.
I am, and I'm smoking on my porch, and that was 10/17, right before my birthday. This was after the addendum that said I could smoke outside and not in the dwelling was passed. So I'm still in confusion of why all of these lease violations are being issued.
This
All right.
video evidence is fascinating because it confirms the act, yes, she's smoking, but it doesn't automatically confirm a violation. Evidence proving behavior is not the same as evidence proving illegality. The tenant openly acknowledges smoking outside, believing she followed the rules. That honesty can actually boost credibility. And notice the judge's thinking process. The question is no longer, did she smoke, but was she allowed to smoke there? That's a completely different legal threshold. When a lease contains exceptions or vague designations like limited common areas, it opens the door for interpretation disputes. This is where many eviction cases turn, not on what someone did, but on whether the written agreement clearly prohibited it. Ambiguity is a landlord's worst enemy in court.
All right, so there's no dispute she's smoking outside of her unit. Ms. Smith, where does it say that she can't do that?
Yes, Your Honor. If you look back at Exhibit
When there's
A6,
sorry, excuse me.
there is dialogue between Miss Couch and Miss Hernandez advising her to
But the dialogue happened, and she told me I had to smoke in front of the office instead of on my porch, which was outside of what they were claiming. She directed me away from my home, which caused me emotional,
Ms. Couch,
mental,
Ms.
and
Couch,
physical
Ms.
damage.
Couch. I'm just trying to read the communications. I'm going to share my screen and see if you identify these, okay?
Yes, ma'am.
All right. So,
and Your Honor, if you could skip if and the copy that was sent to you, there's inadvertently an extra page included. If you'd please skip page 3 of the PDF file. Thank you.
okay, what is this a copy of, Ms. Smith? This looks like a screenshot of something.
Yes, these are screenshots of chats between Miss Couch and the management office.
All right, Ms. Couch, you recognized any of these chats? It looks like this one. Oh, there's no dates on any of these.
That was also me inquiring, not stating that I was smoking in my home. I asked, where am I allowed to smoke?
Okay.
Ms. Hernandez has repeatedly caused disruption and confusion for the Minerva Group and has recently been discharged 2 days after my birthday, which was 2 days before my birthday, which was October 22nd, due to these allegations and threats being made towards me. She threatened me on her daughter that she would come back and get hers. And now I'm looking at this paperwork and they're trying to say that I said that, and none of those words ever came out of my mouth. I sat there silent. It's in video from the lady that took over her job at the Minerva Group after she was discharged that day. And it was for lack of a better term, I don't want to say the S word, but it was a poop show. It was not a beautiful sight. She was screaming and hollering with her and her husband. She had several cars of her associates pull up to my front porch making threats and throwing gang signs and symbols at me on my front porch as I'm trying to medicate with my medical marijuana.
Ms. Couch, please stop. Ms. Smith.
And Your Honor.
Ms. Smith.
Yes, ma'am.
Right here, Ms. Emily writes, as stated in the lease, smoking is not permitted inside the apartment. or within 25 feet of the building. I didn't see that in the lease. Remember, they left it blank in hers.
Which
my apologies, Your Honor.
I don't know
Nathan
who that
Merrick
is.
also.
Someone just
that's
jumped in. I'm not
that's my
seeing it.
colleague, Mr. Merriquin.
Okay.
Your Honor, in section 3, it's the second paragraph. It's the following sentence. It says
Section
if
3 of the original lease, of the addendum, of what?
The addendum, Your Honor.
The addendum. So section 3, smoking
The
permitted
addendum
in
that
and
was never
around.
received until I got the
Ms.
eviction notice.
Couch, I've already found that you signed this addendum. It was given to you when you signed your lease. So this addendum applies. I'm looking at whether it is useful to them today. So now, Ms. Smith, your counsel was explaining to me section 3. Go ahead, sir.
In the middle of section 3, the second sentence, so the sentence following the blank space, it says, if the previous field is not completed, smoking is only permitted at least 25 feet from the buildings in the apartment community.
Fantastic. Thank you. There it is. All right, cool. Ms. Couch, do you see that your lease absolutely told you you couldn't be within 25 feet of the building? And you acknowledged in those photos that you are smoking within 25 feet. You're on your patio.
Ma'am.
Go ahead, Ms.
It
Couch.
also says here, let me please argue my case.
Absolutely.
It says here, smoking on balconies, patios, or and limited common areas attached or outside of your dwelling unit is permitted. So therefore, I was not in violation unbeknownst to me. I don't mean to be, but it said, I'm looking at the lease right now.
I'm looking at it
It's
too,
in
Ms.
my
Couch.
hand.
Ms. Couch, Ms. Smith, what's your response?
Yes, my response, Your Honor, is,
Exactly that.
I'm sorry?
It says that.
It does say that, but it also, as I was pointing to earlier, the paragraph immediately following the sentence that Mr. Merrick
don't
just
understand
read.
the persecution.
Okay, so the paragraph immediately following the sentence that Mr. Merriquin just read to the court, it does talk about that even though it might be permitted in certain limited outside areas, that they reserve the right to direct the tenant and any guests to seek smoking in those areas. And so that is the conversation that Ms. Hernandez was having with Ms. Couch about, we're not strictly enforcing, we're not going to measure 25 feet, but we are saying that you need to smoke not in front of the buildings and
First, you said I had to go off the property 25 feet away from the entrance of the property.
Ms. Couch, please.
Showing the whole conversation, Your Honor.
Ms. Couch. Ms. Smith.
You're picking and choosing information, Your Honor.
Ms. Couch, you're not losing right now. If you'll be quiet, you may end up winning.
Okay. I'm sorry. I'm just nervous. I have
PTSD
and anxiety.
Just be quiet, okay? Because you're interrupting, and that's conflating the situation for us. Ms. Smith, the lease is clear. It says that she can smoke on her balcony and outside of 25 feet of other buildings. If I find that those are in conflict, that's going to work against the landlord because, contradictions go against the drafter.
Here's a powerful judicial principle being stated out loud. Contradictions go against the drafter. In contract law, if a lease contains conflicting clauses, the interpretation usually favors the party who didn't write it. In this case, the tenant. That single doctrine can dismantle an otherwise solid eviction attempt. Also notice the emotional element. The tenant's anxiety and interruptions could have hurt her credibility, but the judge actively redirects and keeps the focus on the written lease. This shows judicial neutrality in action. Personality doesn't outweigh documentation, so now the landlord's challenge isn't just proving violations. It's overcoming the possibility that their own contract language created confusion. If the lease can be read two ways, the tenant often benefits.
Any reasonable person would assume that they could smoke on their balcony, especially because it says that. It's not illegal to smoke marijuana in Texas anymore. We've made that very clear. What is the actual violation? Because these don't do it. And the allegations that she was threatening don't list her. You don't have any witnesses.
And Your Honor, part of it is the redactions and I happy to see
redactions don't work. I need a witness.
Yes, Your Honor. And I don't have a live witness this morning.
I'm a witness.
I don't know who that is. And you just
I'm Cassidy. I'm the regional manager.
Ms. Smith.
Cassidy
is this the woman that I spoke to after that film?
I'm gonna have to mute you because you're.
Yes, I do have the film.
Ms. Smith, do you want to ask this person any questions?
Yes, Your Honor. This is Cassidy Hamel, who's with the Mid-Eviction group this morning.
Yeah, Ms. Hamel, can you turn on your camera so I can see you?
Oh, sorry. What is happening? Why isn't it working?
Always wants to be difficult.
Okay, there I am.
Will you just do me a favor? Raise your right hand. State your
Maybe,
full name for me.
yeah.
Tell me your name, ma'am.
Cassidy Hemo.
You understand you're now being sworn to tell the truth, the whole truth, and nothing but the truth under a penalty of perjury. Do you?
Yes.
Sir? Okay. Tell me what your role is there.
I'm the regional manager of the property.
You work on site.
For the last 2.5 weeks, yes, ma'am.
Do you have any personal knowledge or witnessing of any of the events that gave rise to the notice to vacate?
Yes, I was in communication with the previous manager.
Do you have any personal knowledge or witnessing of the acts that are alleged in the notice to vacate?
Like physically seen him?
Yeah.
No.
This
Okay,
witness
then,
exchange is where the landlord's case starts to truly collapse. The regional manager admits she has no personal knowledge of the incidents. In legal terms, that's hearsay territory, second-hand information without first-hand observation. Courts give far less weight to that kind of testimony. Evictions require a minimum standard of proof, and without a live witness who directly saw the alleged threats or violations, the landlord is leaning almost entirely on documents and assumptions. That's risky. Judges frequently want at least one credible first-hand account to connect the dots. So the audience question here is simple. If you were facing eviction, would you expect your landlord to show up with someone who actually witnessed the events? Because right now, the absence of that person is louder than any email or screenshot.
No.
Okay, then, Ms. Smith, do you got any other witnesses? Because so far, y'all are coming up short.
No, Your Honor, I don't have any other witnesses this morning, who, other than these witness statements, and again, I'm happy to provide the court unredacted copies that might better illuminate, because in addition to redacting names, we
Those
also
have to be
redacted.
given to Ms. Couch, and she has the right to confront those witnesses. I understand the
Yes.
rules of evidence don't come in, and then it's a lot easier, but still,
Sure.
you're not getting there on the smoking, because the addendum doesn't actually prohibit what she was shown to be doing. And if we're going with threatening statements, something more clear than the woman living near the apartment, there in the office.
No, Your Honor, and what I was saying was that the unit numbers were also redacted for some of these persons that might also shed additional light on identifying Miss Couch as the person in these statements.
Put it this way, Ms. Smith, you absolutely can appeal in this the same way as Ms. Couch would have been able to appeal. Today it's going to be judgment for the defendant, lack of evidence for a lease violation. The appeal bond would be equal to 1 month of rent. Ms. Couch, the landlord may very well appeal this and bring with him witnesses to county court. They may do nothing. They may seek to do this again. I wish all parties the very, very best of luck, though, okay?
Thank
Your
you.
Honor.
Good luck. All parties are excused. Thank you very much, everyone.
Thank you.
Your Honor, may I address the court?
Who is that?
Mr. Fritsch. I had the case earlier, 1509.
Okay.
I also had 1510 and you skipped over it, and I'm at 11
Mr.
o'clock.
Frisch, we're going to
Yes.
reach those. We go in a specific kind of order, okay?
I'm 11 o'clock in another court. I was just worried that last case was very long.
Well, I appreciate that, Mr. Fritsch. I'll see what we can do. All right. Ask me at 10:50.
Thank you, Your Honor.
Okay. Thank you very much. All right, everyone.
In the end, this case comes down to a classic courtroom lesson. Evidence must be clear, direct, and specific. The landlord presented volume but struggled with precision, redacted emails, ambiguous lease language, and no first-hand witnesses. The tenant, despite emotional moments and confusion, benefited from contradictions in the lease and the legal principle that unclear contracts favor the non-drafter. The judge's ruling, judgment for the defendant due to lack of sufficient evidence, highlights a broader implication. Eviction isn't just about complaints or suspicion. It's about meeting a legal burden of proof. Even strong allegations can fall apart if documentation and testimony don't line up perfectly. And that's what makes courtroom hearings like this so compelling. They're not decided by emotion alone, but by the smallest technical details hidden in paperwork and procedure. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.